Good morning, everyone. Thank you so much for joining us. We really appreciate you joining us today for this Camp Lejeune litigation update with Beasley Allen. I have a few housekeeping matters to get started. First of all, our marketing team will submit CLE credit for participants who are in Alabama and Georgia. All others will receive a certificate of attendance along with the materials from our webinar and an evaluation. So just to recap, everybody who is attending will get the PowerPoint by email along with an evaluation. For Alabama and Georgia participants, if you dialed in today by phone, please make sure that you send your name, your phone number, and your CLE information to webinars@beasleyallen.com to ensure that you receive CLE credit. And we would really like to make this an interactive webinar. Well, Leslie and I have a presentation to give, but we'd like to reserve at least 15 minutes at the end to answer all of your questions. So as you're listening, if you have questions, please put them in the Q&A box at the bottom, and we will do our best to address all of the questions. I'm going to be presenting today with my law partner and colleague, Leslie Lamacchia. And the way we're going to break this down is I will be focusing on claim submission and the elective option, and then we'll pass it over to Leslie, and she will be focusing on the litigation aspect. So today we're not going to discuss the history of the PACT Act, the chemicals at issue, the maps of Camp Lejeune. Prior webinars that Leslie and I have put on have all of this information. We encourage you to get on the Beasley Allen website and watch them. So today we're really going to dig into the latest updates on the elective option process and where the federal litigation stands. So previously, the VA required veterans to prove that toxic exposure caused their illnesses. And most disability claims for toxic exposure were denied. It is a very difficult threshold to prove that toxic exposure caused an illness. You have to get experts, and litigants just weren't able to meet that threshold. So this act creates a presumption that exposure to certain toxins causes certain illnesses, and it provides both VA benefits as well as a cause of action in federal court. So the PACT Act supersedes a very strict statute of repose that previously blocked these claims. And I'm going to dig in a little bit about these statutes of limitations. So it is our position here at Beasley Allen that we have until August 10th, 2024 to submit a claim with JAG. And we have until February 10th, 2025 to file a lawsuit in the Eastern District of North Carolina. But I would like to tell you that is not a universally held position. Different law firms are handling this in different ways, and I've received a lot of questions on this statute of limitations, statute of repose, and deadline for filing a claim. And I'm just going to talk about some of the other ways that people are handling it or people have addressed it to me. One question I received was, shouldn't the deadline be August 9th instead of August 10th to submit a claim? Well, the Camp Lejeune Justice Act states on its face, I'm going to read a little section of the statute. Statute of limitations. A claim in an action under this section may not be commenced after the later of, and then there's A and B. A is the date that is 2 years after the date of enactment of this act, or B, the date that is 180 days after the date on which the claim is denied under Section 2675 of Title 28 United States Code. So first I'm going to talk about the submission of a claim deadline. President Biden signed the act on August 10th, 2022. I did an analysis under the counting rules of Federal Rule of Civil Procedure 6A1, and I looked at some federal case law, and it is my conclusion that the date to file a claim with JAG is August 10th, 2024. If you are concerned that you think it might be August 9th, submit it on August 9th. We're only talking one day, and I can't imagine I'm going to be submitting very many claims on that last day. Let's hope I'm not anyway. So stick with August 9th if you feel concerned, but I feel pretty confident that it's August 10th. Secondly, as for the statute of limitation to file suit, I have heard three different opinions. The method that Beasley Allen is taking, I believe, is the most conservative approach, and that is February 10th, 2025. So the reason that there are some different opinions out there is because I'm going to read this section B again. It says the later of the date that is 180 days after the date on which the claim is denied. Nowhere in the statute does it say that a claim is actually deemed denied after 6 months or 180 days. So that's where it gets a little bit confusing. So, and then secondly, even if a claim is denied after 180 days, then there would be an additional 180 days before the statute of limitation runs. So let's say that you filed a claim on August 10th, 2024. It's deemed denied on February 10th, 2025. Then some people are reading the statute to say you would have an additional 180 days to file your lawsuit. Right now, we are calendaring our deadline as February 10th, 2025, and we may change that with leadership guidance, court guidance, case law, but I see ambiguity in the statute. I think it's a little bit confusing, and why risk it? Now, I will tell you the third analysis of the statute is that there is no statute of limitations. There are plaintiffs' attorneys who believe that because of that word "or" in the statute, that there is no statute of limitations to file a claim or file a federal lawsuit in the Eastern District of North Carolina. So I'm just giving you all of the different thoughts out there and tell you the way that we're proceeding with it for now. So I've shown you this before. I hope that many of you are repeat attendees, and thank you for attending our webinar. This is an internal document that Beasley Allen created. We like to give it to our clients to kind of lay out the process of how we file a claim. And you see step 1 is submitting a claim with JAG. Step 2 is filing a lawsuit in the Eastern District of North Carolina. It just kind of lays out for clients to understand, why do I have to keep signing these documents, and it shows all of the different things that we have to do. And so, as we said earlier, you're going to receive a copy of this presentation. You're welcome to use this document as you see fit. The next slide is just to zoom in, because I'm going to be focusing on step 1, which is submission of a claim. So what I'd really like to talk about today is the elective option, because there is some new guidance on how to submit a claim. So first, I'm going to talk about the requirements of a claim, and then I'm going to talk about the submission of the claim. Have you communicated the elective option to your clients? It's very important, just like any settlement offer, that they need to be kept in the loop. It is really a tough decision to determine whether this is the right option for your client. So first, I'm going to talk about the 30,000-foot view of the 5 requirements. And assuming that your client meets all 5 requirements, what should you advise them? Should you tell them to accept it, or should you tell them to elect it, or do at least present your settlement package, or should you advise them to continue on and litigate? So the 5 requirements are: you must have a qualifying injury, you must have the proper duration of exposure, 30 days or more, but that gets more detailed as I will explain. Presentment is you must file or submit a claim with JAG. Onset, there's a certain amount of time that you have to have been diagnosed with the illness or injury after leaving Camp Lejeune. And latency. So I'm gonna dig into each of those, but let's just make the assumption that your client meets all 5 of those requirements. Do you advise your client to make an elective option submission or not? I would say, first of all, it is a very limited option. Probably less than 1% of our clients are qualified and are interested. And there are a lot of compensatory limitations to this offer. If your client has more than one qualifying injury, you are limited to selecting one qualifying injury for your client. That could be, leaving money on the table if you didn't want to litigate the case and they had more than one qualifying injury. Other limitations are the latency period. And so you just really have to dig in. And I advise you to think about what this specific case would get at trial. So look at the age of your client's diagnosis. Think about the treatment that he or she underwent, the risk factors. Is there a family history? The length of exposure. Perhaps it would only be, if they were only there for 30 days, maybe a jury wouldn't think that this is the strongest claim. Think about your client's personal financial situation and their health. Has your client been given a terminal diagnosis? Do they have 2 years to live? Do they need this money now? So those are kind of some of the thoughts that we go through. It's a very specific, individualized discussion, and you just really have to take your time with your client. Also, it's important to remember when discussing this with your client that the elective option has a 20% attorney's fee requirement for if you make the elective option while still in the claims phase, not in the litigation phase. And there will not be a VA set-off. You still have to pay any private liens for private treatment that you would have received. We do not know how that is going to be in litigation. Will there be a fee cap? We don't know. Will VA liens be forgiven in litigation? We don't know. So it's just something to discuss in open, honest communication with your client. So now I'm going to go through each of these 5 requirements for the elective option. The first is qualifying injuries. As you can see, this is what a government created document. And the government did not consult with plaintiff's leadership counsel on this. They did it unilaterally. So I just want to show you that this is a different tiering system than what has been called the Track 1 and Track 2 discovery pool. So the court has requested and excluded the term bellwether and requested counsel to use the term discovery pool. So that's what I mean by this. So if you look at, for example, Parkinson's disease, on this elective option qualifying injury, it is listed as a tier 2, but it is considered a Track 1 discovery pool injury under Case Management Order 2, which Leslie's going to talk to you about a little bit later. So liver cancer is not a Track 1 disease, but it is a tier 1 disease. Okay, we can go to the next one. Now this talks about, is again, part of the government's a document that they created. This is the settlement elective option grid that they created. So if you have a tier 1 qualifying injury, kidney cancer, and you were at Camp Lejeune for less than a year, then you would qualify for up to $150,000. And I said up to. Doesn't mean that your client is going to automatically receive $150,000. It's going to depend on proof and treatment and documentation, and we'll get into that in a moment. So also, if there is a wrongful death, so remember that a wrongful death has to be caused by a qualifying injury that is listed on the death certificate, then you add another $100,000. So if we had a tier 1 qualifying injury of kidney cancer and our client was at Camp Lejeune for 6 years and they died of kidney cancer and it is listed on the death certificate as the cause of death, they would qualify for up to $550,000 settlement under the elective option. And remember, no need to go back to the previous slide, but just remember you can only submit one qualifying injury, so you can't stack these. The remaining three requirements for the elective option are presentment. We have talked about that for the administrative claim. You have to have submitted an administrative claim done. Onset. So, as I've mentioned, this is a document that was created by the government, and it says that the injury must have been first diagnosed or treated before August 10th, 2022, the enactment of the PACT Act. So I would encourage you, if you have a claimant with Parkinson's disease, for example, Parkinson's disease is notoriously difficult to diagnose. And if they had an essential tremor or Parkinsonism diagnosis in 2021, and then went to a specialist in 2023 and received their Parkinson's disease diagnosis, and this claimant really wants to submit an elective option package, you can fight for your client here. I think that you can advocate for your client if they really want that. So just consider that that this document does say diagnosed or treated. So we'll talk about this again later in another document, but then the final requirement for the elective option to apply is this latency requirement. And this is when I have to get out my scratch pad and do math. And, this is why I'm a lawyer and not a mathematician, because I'm not good at math. But you have to figure out the date of the last exposure of your client within the, confines of the Camp Lejeune Justice Act. So before December 31st, 1987. And make sure that their diagnosis was not more than 35 years after the claimant's last exposure. So I would just like to mention here that the 35-year latency requirement is arbitrary. We haven't seen any science to back it up, and we don't know where the government got the 35 years, and it does exclude a lot of clients from being able to participate in the elective option. Because if you think about it, we're talking about exposure from the 1950s, 60s, 70s, and a lot of these claimants were diagnosed more than 35 years after exposure. All right, so we've talked about the requirements for the elective option. And let's assume that your claimant or client qualifies and wishes to partake in the elective option. What do I do next? What is the next step? So we're now going to talk about gathering and submitting your elective option settlement packages. This is new. The government rolled out the elective option without creating a method to actually apply for it. So they've talked about creating a portal. It has not yet been created, but recently we received an email from Plaintiff's Liaison Counsel stating that you may submit a claims package to Attorney Adam Inch. I have his email here, and all you need to do is send him an email and ask him for a link for a safe exchange platform. And he will email you a link. That link is active for 2 weeks. And you have to submit the required documents. And he will also give you a checklist, and that's what we're going to go over next. So again, this is another document that's created by the government, and the purpose is to try to streamline the documents that are required to submit an elective option settlement package to this email address. So step one is presentment of a proper claim. As you know, you have to have submitted a claim to the Department of the Navy to apply for the elective option. Step two is proof. All right. And so let's dig into what proof entails. This is the checklist, but I'm going to go over it in big form, and then I'm going to drill down in detail. So the first thing you need to do is a copy of the administrative claims form. You've got to prove your client's identity, for example, a driver's license. Then you've got to prove that your claimant was at Camp Lejeune. There are several different ways that you can do that, but it is limited. You have to prove your qualifying injury, medical records. you have to prove, if you have a personal representative, you have to prove that they are an authorized representative to have brought the claim. And then finally, if you have a death claim. So I'm going to go through each of these in detail. Claimant's identity. For the claimant itself, you've got to provide driver's license or military ID, or if you have, passport, something like that. If you have a civilian spouse, you must have a marriage certificate, a dependent, a birth certificate. Proof the claimant was at Camp Lejeune. This is where I have come across some problems where I have a client who wants to, I believed was eligible and who wants to apply for the elective option, but then I look at the DD 214 and it doesn't show that they were at Camp Lejeune. What they have is witness testimony or, mail or photographs or other creative evidence proving that they were at Camp Lejeune, but this elective option checklist created by the government states that you must have a DD 214 or other military discharge document that shows start and end dates at Camp Lejeune. So other military records they will accept would be fitness reports, evaluations, award citations, permanent changes of station. But again, these are all documents that would be created by the military in order to effectively apply for the elective option. If they were a veteran, you have to state whether they applied for VA benefits. And remember, please remind your claimant or your client that it's not going to take away their benefits. That's a big fear, and it's not going to. If you have a civilian contractor who worked on base, you need to provide housing or employment documentation. So yet again, this is narrowing the amount of claimants who can actually apply to this if you have other evidence that is not what is listed on this form. But that doesn't mean you need to, discourage your client. It's just you might need to go through the litigation process. The qualifying injury, obviously, you have to have one of the qualifying injuries listed in the elective option, but after that, you need to show a signed medical documentation, and what that really means is provide a full medical record. Don't just give the one piece of paper that says the diagnosis without the doctor's signature on it. Onset. Now, this is what I talked to you about that I was going to come back to later. This document states must show date of diagnosis was before August 10, 2022. It does not say or treatment. So that's just something for you to decide if you would like to fight for your client on that issue. Latency, as we talked about, I don't have any science behind this, but this is what the requirements are. More than 2 years after claimant's first exposure and less than 35 years after claimant's last exposure. And it tells you what appropriate medical documentation is included. Personal representatives, claims brought by have to be brought by an authorized personal rep, and you have to show authority. And finally, wrongful death claims, you have to have a death certificate with cause of death showing the qualifying injury. So as you go through this is a playbook for what the government is going to want for a matrix to settle these claims eventually. So I think this is a really nice list. It's a start. I think that we need to greatly expand the types of proof that we can provide to show that our clients were at Camp Lejeune, but this is a start. So use this to build your clients' files. All right, so now I am going to pass this on to Leslie, and she is going to talk about step 2, the litigation process.
All right. Thanks, Julia. So you submitted an administrative claim and 6 months have passed and you do not want to opt in, or your client does not want to opt into the elective option program, and your claim has now been deemed denied by JAG. And so now it's time to move into the Eastern District of North Carolina. So now you're under the Department of Justice umbrella and no longer with JAG. And as Julia said, it's Beasley Allen's position that, any lawsuits in the Eastern District of North Carolina need to be filed by February 10th of 2025. And again, this is just and you'll be given a copy of this, but it's our step-by-step process as to how we explain to clients when we're moving from the administrative claim process to the actual filing of a case in court process. And one of the specific sites you should familiarize yourself with, and there's going to be others that I'm going to share with you during this program, is the actual Eastern District of North Carolina's website. A lot of information can be found on here. And also what's very important to note here is the order that was entered on April 24th of 2023 regarding for your motion for admission pro hoc vice if you are not a licensed North Carolina lawyer and admitted into the EDNC. The motion for admission pro hoc is here along with the fees. And the Eastern District of North Carolina has now waived the 3-case pro hoc limit for any Camp Lejeune cases. So far, what's happened in court, I'm not going to read all these, but there have been 8 case management orders entered thus far. There's been a proposed CMO 9, but has not been entered yet. And so I put an asterisk on CMO 2 because I'm going to get in depth. I'm going to go in depth on CMO 2 in subsequent slides, and I believe it's the most important CMO to date and one that I suggest you familiarize yourself with. I'm going to show you several sources where to find all these orders later, but we're going to go into CMO 2 in depth now. So CMO 2 was entered by the court on September 26th of 2023. It was a very comprehensive order, 13 pages. And what it really did was it laid out process for selecting claimants based on certain diseases. It created a trial plan and a discovery plan. And CMO 2 basically said that each party, plaintiffs and the government, needs to select 50 plaintiffs for each track illness. And so far, CMO 2 set out track 1 illnesses, but it also laid the foundation for what's going to happen in track 2 and track 3 illness as well. And so I know if anyone else is on here, we're so used to, pre-trial cases being selected and worked up for trial being known as bellwether cases. The court here has wanted to refer to them as track 1 cases and not bellwether. So track 1, which diseases were included in track 1? These were, I call the big 5 of track 1, non-Hodgkin's lymphoma, leukemia, bladder cancer, kidney cancer, and Parkinson's disease. And as Julia mentioned earlier, these are not the same injuries as tier 1 under the elective option. Okay, and a quick timeline. On December 5th, both parties exchanged the names of 50 claimants in each of the 5 disease states. They were divided somewhat proportionally among the judges, and there were 100 total claimants in track 1. But then on December 12th, plaintiffs' leadership group moved the court to void the government, 17 of the government's track 1 selections, because they said that the government was in violation of CMO 2. That is still pending before the court has not ruled on, but as of now, there are 100 claimants in track 1 being worked up. And the discovery period per CMO 2 says that the discovery period goes from January to March of this year. So far, the first deposition took place on January 5th, and the government has noticed up 51 thus far. So for each plaintiff, there will be 3 fact depositions and 1 treating doctor deposition. On January 19th, which is in 2 days, the defendants, the discovery pool profile form, the DPPF for track 1 cases are due. This is sort of like a plaintiff fact sheet for other litigations you might have been involved in. The track 2 illnesses have not been decided yet by the court, but they will be governed under proposed CMO 9. Plaintiffs have proposed liver cancer, multiple myeloma, systemic sclerosis and scleroderma, other kidney diseases, and aplastic anemia. And you can see on the right side, defendants' proposed track 2 illnesses are prostate, breast, lung, pancreatic, and esophageal cancer. And so these numbers, what they are is that they're those cases that have been administratively filed and that are ripe for filing now for lawsuits in the Eastern District of North Carolina. So 6 months have expired for these diseases, and if these lawsuits, they're ripe for filing. Track 3 is very interesting. These illnesses that were proposed, the plaintiff's proposal is the government's track 2 illnesses. I'm going to go back so you can see track 2 illnesses. Defendants proposed are the same that the plaintiffs are proposing for track 3, with the exception of childhood leukemia. It will replace the pancreatic cancer. And you can see the government's proposals are any of the 5 diseases that are not selected for track 2, plus any cases that don't allege any specific disease, but allege medical monitoring, in addition to cervical cancer, miscarriages, non-cardiac birth defects, and neurobehavioral effects. So like I said before, neither track 2 or track 3 has been decided by the court. So if you are currently considering filing any cases that are proposed track 2 or track 3 illnesses, remember that they can be considered part of the discovery pool going forward, and look to plaintiffs' leadership group for further guidance on whether or not you should be filing proposed track 2 or track 3 illnesses at this time. All right, so CMO2 also had an amendment to it, and it specifically addressed the notice of appearance. CMO2A is that plaintiff's counsel must file a notice of appearance in each individual Camp Lejeune Act. If you are not admitted into the Eastern District of North Carolina, you still have to file a motion for pro hoc vice and get local North Carolina counsel. So I want to reiterate, CMO2, along with its amendment, are very important that you familiarize yourself with and read if you are ready to file lawsuits in this case. All right, so now that you're ready to file a lawsuit, what are you going to really do first? Well, the first thing you're going to do is watch a Rubris webinar regarding Crosslink and get registered. I am going to provide you specific links and information at the end, but first I want to talk to you about Rubris and what its role is in the litigation. So what is it and what does it allow you to do? So this is the litigation management database for all claims that are going to be filed in the Eastern District of North Carolina. This is not optional. This is required. The court has required this. This is where all of the electronic court filings are stored. This is where you're going to create plaintiff information. This is where you're going to type in your information that's going to go in the short form complaint that will be generated by Rubris by PDF that you will then be required to download and file with the court using Pacer. Okay, it's a collection of data. It allows us to generate reports and plaintiff's leadership group to generate reports that will hopefully come into play at resolution. So for anyone else who has, maybe you've never used Rubris before, but you've used Brown Greer or MDL Centrality in your mass tort litigations, this is what Rubris is going to do. It's a great platform. And if once you're set up and registered, if you have any issues, you can email Rubris at crosslinksupport@rubris.com and they get back to you right away. Okay. I'm going to just show you really quickly what the platform does look like once you get in there. On the left-hand side, you'll see it starts with claims. Once you get in there, claims is where you will set up your plaintiff and anything associated with the plaintiff. The court filings are what is filed in court and is updated live on Rubris, and you can download the documents and read every document that's ever been filed in the court. And then there's a bunch of other options on the left-hand side, including tasks. So for example, if you had generated your short form complaint, but not yet downloaded the PDF, it'll give you a button that says download PDF. So it tells you what tasks have not been done specific to your claim. All right, so now that you are registered on Rubris, you're going to enter all of the information and it will generate a short form complaint, which looks just like this. And it was attached also to CMO2. And again, you still have to file this on Pacer. If you filed a regular complaint, if you were already filed in the EDNC before CMO2 was entered in September of this past year, and you haven't filed a short form complaint yet, you're okay. It is stayed. But what you can do now is you can now go back and file a short form complaint. You are not penalized because you were not in track one. Track one selection is done, so you can do it now. Okay, so if you've not yet done it, do it now, get registered through Rubris, and you're good to go. All right, this is the exciting part. The current status of the litigation. As of yesterday, there are 1,483 cases filed in the Eastern District. You can see they're somewhat equally divided amongst the judges, Judge Dever, Judge Myers, Judge Boyle, and Judge Flanagan. There are 158,252 administrative claims on file with the Department of the Navy. So far, per CMO2, there have been requests for production exchanged by both parties. Specifically, the government has propounded requests for production on the 100 claimants that are currently in track one. RFPs by plaintiffs so far include requests for digitized muster rolls, housing records, ATSDR water modeling. So all of these requests are being done. There's also been motions to compel that have been filed. As of yesterday, an update was given to the court that about a half a dozen or more special masters were interviewed, and one was being jointly recommended to the court by the name of Tom Pirelli of Jenner and Block. Maybe some of you have all heard of him or worked with him before. He was recently appointed as the Jewel settlement special master, and he also was involved in the 3M settlement. And the judge also recently has requested positions on settlement at his next status conference, which will be next week. Before I talk about settlement or resolution, I want to explain to you that there are two current pathways for the Navy to assess the Camp Lejeune Justice Act claims. The first one we already talked about, and that was through the elective option program. So the Navy is receiving substantiating information from you. So you're being invited to submit fully developed claims for assessment by the Navy. And currently, there are 10 firms that I know of in the process of submitting packages. And the second is the Navy accesses information. This is relatively new. The Navy accesses information developed through the benefits determinations by the VA. So there has been an agreement between the VA and the Navy that is allowing the Navy direct access to the VA database, which has this information to assess any Camp Lejeune claim. So this is brand new. As of tomorrow, the Navy is going to invite the first 8 law firms in chronological order of bulk filed claims into the new claims management system to validate existing claims and being able to start uploading substantiation documents directly into the claims management system. I know that Beasley Allen will be holding another webinar in a couple months, and hopefully we can provide you additional information with regards to this in this process. But I am also going to provide you with some links at the end where you might be able to stay tuned to what's going on in real time. All right, update on individual and global settlement efforts as of yesterday. This pertains to the elective option. There were 37 cases in litigation that met the elective option criteria. 4 were accepted, 3 were rejected by the plaintiffs. 6 offers have expired, and there are 24 offers still pending. And there's the current breakdown of the injuries that were eligible. And this is the second pathway I was telling you about, where the Department of Justice approved offers for 52 claimants, relying on the information provided by the Navy. 8 were accepted, 2 rejected, 10 expired, and 32 pending. In these 8 cases that were accepted, payments were sent in these 8 cases, totaling $2.2 million. If you want more specifics on these payouts, a status report came out yesterday. It's document 113, and it'll tell you what payments for what injuries, how much what each injury received. There are ongoing discussions for global resolution of all claims. Plaintiffs' leadership group and the government continue to meet and figure out a resolution questionnaire and a resolution roadmap. We shared that with you in the November webinar. So if you attended, those slides were part of that presentation. Okay. So you are going to receive copies of our slide deck, but here's some resources that you can refer to for some information. This one's my favorite, the one at the top. It is it's a website maintained by Plaintiffs' Liaison Counsel, which was appointed by the court, Warden Smith, in this litigation. It's very comprehensive. It has all the, information with regards to what's going on in court, documents that are on the docket, orders, pleadings, status reports, pro hoc vice information, short form complaint filing information. So that's there. And I'm going to quickly show you what it looks like. As with regards to Rubris, what you would do is you would click on the short form complaint link, and that's going to give you, it's going to pull up an order that was dated November 20th of 2023 by the court. It shows you how to access Rubris, watch the webinar with a password that's provided to you. Okay, so you can start there. And then here's some other resources to access Rubris. There's their website, and then to order military records. I just want to point out here, when you're ordering military records through this website, you get to a question and it asks you, is the ordering of these medical records related to the Camp Lejeune claim? If you click yes, it stops you. It doesn't allow you to order medical records. So what we've been doing is we're clicking no, and we continue on through the process of ordering medical records. So don't be discouraged by that. Just click no and move on. Again, I'm sorry, this is just the screenshot of the home page. And so now I think we're going to open it up to questions. And I know that looks like the chat box is full of questions. So be patient with us, and we'll go through these since we don't have a moderator today. And if you do have any further questions and we didn't get to your question, go ahead and email either of us, and we'll get back to you.
Thank you, Leslie. Good job. I'm going to read out some of the questions that I think would be relevant for everyone. And I'll answer the elective option ones, and Leslie will answer the litigation ones. So the first question is from Zachary, and it says, I believe I have a client that meets the 5 criteria for the elective option. However, we have received no communication from JAG regarding this case. Logistically, how have these offers been received? So I will tell you, and there are several questions in the chat about this. We have submitted thousands of claims, and I haven't received any substantiation requests or perfection letters, except for 22 claims that I submitted back in August of 2022. So the vast majority of our claims have received zero communication from JAG. After 6 months, you can file suit. Immediately after filing the claim, you can submit a settlement package via the email to Mr. Inch, and you don't have to wait for any response from JAG. So you can just go ahead and submit your settlement package. Leslie, I'll give this one to you. This is a question from Keith. And the question is, has the court signaled any willingness to consider or create an expedited estate formation process?
Not as of yet, unfortunately. I mean, it's, we all want this to happen, but it hasn't happened yet.
Mhm. All right. From William, I am still having problems obtaining military records. Is that normal? With one client, they say the records are, quote, checked out. Leslie?
Sure. This is a common problem. There are hundreds of thousands of submissions for military records. We've requested them a couple times. There are records that DD 214 records that we requested back in September, and we still don't have them yet. What I would do is just make another submission, and also don't just order the DD 214, order the official military personnel file also, and maybe you'll have some luck.
Okay, Michael asks, pancreatic cancer death claim, would that qualify if the claimant was at Camp Lejeune for under 2 months? We would submit that claim, yes. The statute says 30 days or more. And so I believe pancreatic cancer would be absolutely a qualifying claim for a death claim or a personal injury claim. Another military record request question: how long is it taking for DD 214s to process? Sometimes it's taking pretty quick. I mean, we're getting some of them in a week, and sometimes it's taking longer. So Leslie kind of addressed that previously. There's a huge backlog. Leslie, do you want to address this question from Robert? Has there been discussion of dates that settlement checks shall be sent for the elective option?
No, I've heard, rumor has it, that once there is an offer and the client accepts the offer, the turnaround time has been pretty quick. But I don't have any specifics as to how many days. There are a couple firms that had clients that did accept the offers, and they indicated to me that the turnaround time was pretty quick. I think we'll get more information in the coming months after more of these packages are submitted. But as of now, I can't give an exact number of days.
All right, so this is a question from Russell. If we do not have proof the client was at Camp Lejeune at this stage, and we are uncertain if we are going to obtain it, at least from standard military forms, can these claims still get submitted to JAG? I would say yes, if you believe your client, if your client has, a good reason to believe that he was at Camp Lejeune for more than 30 days, you do not need to have that proof in order to submit a claim with JAG. You do need to have the proof in order to, submit your elective option claim and likely to file suit. But remember, you can be creative with proof. It doesn't have to just be military records. Witness affidavits, mail, photographs, old newspaper clippings. So try to get creative with your proof. I'll answer this next one as well. It's about the elective option. So Tammy asks, doesn't the client have to be made an offer through the elective option? In other words, they may qualify, but doesn't an offer have to be made to them first? So let me clarify that you have to submit your elective option settlement package, and then an offer has to be made, and then the client has to decide whether to accept it. So that is the format. Leslie, how about this one? For non-presumptive illnesses, Heidi asks, are you obtaining experts to get causation opinions prior to filing a claim with JAG?
For non-presumptive illnesses, we have not hired, well, we've consulted with some experts with regards to chemicals and potential causation, but we didn't really hire any experts for an opinion. But I don't know how to answer this one in terms of, the answer is we've used consulting experts to determine whether or not we believe there's a viable claim. And we've submitted that claim based on the information and or literature or opinion that the consulting expert has provided to us.
Yes, I agree with that. Russell asks a question, and this is a Rubris question for Leslie. Is it a good idea to go ahead and register with Rubris and begin inputting plaintiff information now, even if we are not ready to file suit?
That's right. You can go ahead and type in the information of your plaintiff. And again, it will generate a PDF and it will be up to you to file that lawsuit in court. So you can input the information, they're collecting data. It's going to be there in your little portal page with all of your claimants. So you can start doing that now. And if you have more than one claimant, or let's say you have 100 or 150 claimants, you can speak with Rubris about how you can import like a CSV or information to their portal. So you can do a bulk upload.
And a follow-up question to that, Leslie, from Allison, do you have to already be in litigation to register for Rubris?
So I'm understanding that question. I mean, do you have to have already a case on file, or?
Let's say that, yes. Do you have to have
Okay.
already filed suit to register for Rubris?
Yeah. So listen, if you've already filed a case prior to CMO2 being entered, you still have to file a short form complaint. Okay. You've got to still register with Rubris and get a short form complaint filed. Even if you had the general complaint filed before, you have to do that. So if you want to, I want to say, if you want to participate in this litigation and ultimately file lawsuits, you've got to register, and you've got to register with Rubris and put all your data in there.
Okay, Heather has a question about the elective option, and it is, can you file under the elective option if your client has both qualifying and non-qualifying injuries? So the answer is yes, except you're going to preclude your client from being able to collect on more than one injury, whether it's qualifying or non-qualifying. So if your client has, let's say, kidney cancer and prostate cancer, you would only be able to claim kidney cancer as a qualifying injury, and you would have to waive your prostate cancer. You cannot accept the elective option and then continue on with the remaining claims. So you have to waive your remaining claims and injuries. All right, let's see here. Here is a question from Jacob. If we filed a claim in early 2023 and the Department of Navy has not denied it, do you believe the statute of limitations for filing a lawsuit on that claim is still February 10th, 2025? Yes, that's what we're operating under right now. That's our best analysis of the statute, yes. A question from Michael. What is the status on filing death cases and the requirement of probate? Has this been addressed with any of the filed cases? Leslie, you want to address that?
Yeah. So this starts,
but...
yeah, this starts actually at the administrative claim filing level. In order to file an administrative claim, you have to do so with proper authority, proper representative authority, that the person filing the claim can actually do so. And so I think there is a requirement of probate unless you have some other documentation that appoints them as the proper representative of the estate. And so for filing death cases right now, I mean, it started at the administrative level, but if you're going to file death cases, yes, we are currently opening estates for our clients. So we are probating everything, getting the proper party appointed. And has it been addressed with any of the filed cases? I don't know the answer to that because we're doing the probate process and doing it all together. So I don't know what other firms have been doing, but this is what we're doing.
Mm-hmm. So just to clarify, we are opening an estate prior to filing an administrative claim or filing suit.
Yep.
All right, this is a Leslie question. You're so good at medical records. So from Katie, do you have any suggestions on how to obtain base hospital records? For instance, people that were born there, we have submitted records through the NPRC, but have been waiting almost a year.
Yeah, so I'm assuming they were born at the Naval Hospital there, and I don't really know, if you've submitted the request and you're waiting. I don't know how else to answer that. I know there's a lot of Naval Hospital requests that have been waiting and pending. I think it's also part of leadership's request for production and things that happened on base that we're trying to get records as such, right? Like there's going to be Naval Hospital records that I think we'll probably be able to get, or um, I don't know. Katie, I think just email me and we can walk through this, because I want to see like the case specifics, if they were born there, if we can get some other records that will substantiate your claim for any kind of illness, or if maybe it was a miscarriage on base that you're looking for. But I think this is a client specific question, and go ahead and email me and I'll walk through some of the issues and maybe we can troubleshoot it.
Okay, Leslie, we have some questions about the litigation from Kana. If we have not yet filed a lawsuit and our client falls under track 1, what does that mean?
Well, it doesn't really mean anything. Track 1 cases have already been selected for discovery. So it's not included. Your case is not included in the discovery pool, but it'll still sit in court, and it's sitting, wherever judge has been assigned to that case, it'll sit in that judge's court. There just won't be any discovery being done on that track 1 case right now. But if you haven't filed it, and you want to file it, it's just going to be filed.
Okay, thank you. And then another filing question from Jen. Does filing the lawsuit in North Carolina trigger any discovery deadlines for plaintiff fact sheets or profile forms?
As of right now, the only discovery deadlines are those that are part of track 1 discovery pool. So nothing else right now.
All right, I'm going to answer a question from Jennifer. Once the claim is emailed or filed, do we get anything confirming receipt of it? And I've gotten so many emails about this from other attorneys that you submit your claim via email, whether it's in bulk or individual, and you receive nothing back from JAG. That is very common right now. So don't feel alone on that. I personally am always getting just standard form email saying we have received your claim, but not everyone is getting that. So just document your file, show that your email was sent, have a cover letter, and be sure that you document the date and calendar, everything for your own records. Okay, Amber has a question. If you have already submitted a claim form to the Navy, can you submit an EO package afterwards? Yes, that in fact is the process that you have to follow. First, you have to submit a claim form to the Navy, and then afterward, you can submit your EO package to Mr. Inch by the email address that we provided previously. Let's see. A question.
Time for one more, Julia, because it's
oh
yeah.
Okay, let's see. We filed, okay, this is a timing question, then we're gonna have to log off. And if we haven't answered your question, please email Leslie or me or both of us, and we'll be happy to work with you, okay? Question from Justin. We filed claim forms in October 2023. Can we file suit before 180 days, or will the short form complaint be thrown out?
Yeah, you have to wait your 180 days.
All right, well, it is time for us to close. I have a couple of closing remarks to remind everybody about these housekeeping issues. Our marketing team will submit CLE credit for participants in Alabama and Georgia. All others will receive a certificate of attendance along with the materials from today's webinar and an evaluation. We appreciate that you submit that and send it back to us. So remember, you will get this PowerPoint from today. For Alabama and Georgia participants, if you dialed in via phone, please send an email to webinars@beasleyallen.com to ensure you receive CLE credit. And please be sure to check out our events page at Beasley Allen to review upcoming webinars throughout 2024. And we will be presenting another Camp Lejeune webinar in a couple of months. Thank you all for attending. We appreciate you very much.